A former business partner sued Jake for breach of contract. The court awarded a $500,000 judgment. Since Jake owned everything in his name, they seized his bank accounts, put a lien on his house, and garnished his wages. Within 90 days, Jake's empire collapsed. The same partner tried to sue Mark. The attorney ran an asset search on Mark personally. They found nothing. Absolutely nothing. All of Mark's wealth was hidden behind the ironclad walls of those Triple LLCs. The lawsuit was dismissed because Mark, legally, owned nothing. Jake thought the goal was making money. Mark knew the goal was making himself uncollectible. He did it using a hidden legal blueprint called the Triple LLC Vault, a structure the top 1% use to ensure no lawsuit can ever touch their wealth. That blueprint isn't theory. It's a precise legal architecture used by every billionaire from the Walton family to Robert Kiyosaki. And the mechanics are not taught in any school. They're deliberately hidden behind complexity because a population that knows how to make assets legally invisible is a population that can't be financially enslaved. Here's exactly how the Triple LLC Vault works, why it makes personal bankruptcy mathematically impossible, and the step-by-step layering system that turns a regular business owner into a judgment-proof ghost. The single greatest financial mistake a high earner can make is holding assets in their own name. It's the equivalent of walking through a hurricane in a wet paper suit. In the United States, there are over 40 million lawsuits filed every year. 1 in 3 doctors will be sued. 1 in 5 small business owners will face a lawsuit that threatens their personal assets. Yet the average financially literate person still registers their home, their brokerage account, their rental property, and their business directly under their Social Security number. This is personal ownership, and it's an open door. The moment a judgment is entered, everything tied to that individual's name becomes a sitting target. Bank levies, property liens, wage garnishments. They're all legal, they're all automated, and they happen faster than a lawyer can draft a retainer. The rich do not play this game. They haven't played it for over a century. John D. Rockefeller didn't personally own Standard Oil shares. He owned a trust that owned a holding company that owned the shares. When he was sued, the lawyers discovered a legal maze. When Jake was sued, they found his name on a deed, a title, and 3 bank accounts in under 10 minutes. That's the difference. The foundation of the protection is a cold legal truth. You cannot lose what you do not own. The Triple LLC Vault doesn't hide assets in the shadows. It legally separates the human being from the wealth, so the human being appears destitute on paper while controlling millions. The vault consists of 3 distinct entities, each with a separate function. This isn't an LLC. This is an ecosystem designed to isolate liability, create anonymity, and weaponize a legal device called the charging order. Layer 1 is the Operating LLC. This is the entity that deals with the public. It runs the business, signs contracts, processes payments, and faces the market. It's the frontline soldier that gets shot. It's deliberately kept asset thin. It holds just enough cash to operate and nothing more. If it gets sued, and it probably will, there's almost nothing to take. The Operating LLC leases equipment, rents space, and even licenses intellectual property from the second layer. Layer 2 is the Holding LLC. This is the fortress. The Holding LLC owns everything of value: real estate, equipment, intellectual property, investment accounts, and liquid cash. It never interacts with customers, never signs a vendor contract, and never accepts direct liability. It simply collects rent, royalties, and distributions from the Operating LLC. In many structures, it's formed in a state like Wyoming or Delaware that offers the strongest charging order protections in the nation. A charging order is the nuclear weapon of asset protection. It means that even if a creditor somehow wins a judgment against the owner of the Holding LLC, they cannot seize assets. They can only get a lien on distributions. And if no distributions are made, they get nothing. Forever. They own a piece of paper that generates $0 while accruing legal fees.
Layer 3 is the anonymous trust ownership. The LLCs themselves are owned not by an individual, but by a trust, often a South Dakota or Delaware asset protection trust, or a simpler revocable living trust with anonymity provisions. The trust is managed by a nominee or an independent trustee. This puts another legal firewall and a stack of privacy between the human and the assets. Public record searches turn up the trust's name, not the individual's. Asset searches go cold. This three-layer architecture transforms the individual into a manager, not an owner. They control everything, they own nothing. That sentence is the entire game. In most states, if a creditor gets a judgment against an LLC member, they cannot simply walk into the LLC and take the assets. The law limits their remedy to a charging order. The creditor becomes an assignee of the member's economic interest. They step into the shoes of the debtor only for distributions. Here's the trap. The remaining members, or the trust that controls the LLC, simply vote to never make any distributions. Profits stay inside the LLC, reinvested, or paid out as tax allocations that don't constitute actual distribution income. The creditor is legally required to pay income tax on their phantom share of the LLC's profits, even though they received zero cash. They're handed a tax bill on money they can't touch. This is called phantom income, and it's the primary reason creditors quickly abandon charging order cases. The Triple LLC Vault leverages this principle across every layer. Judgment against the operating LLC. It owns nothing. Judgment against the member personally. The holding LLC issuing no distributions. Judgment against the trust. The trust is a separate legal entity, and the assets inside are vested under spendthrift provisions. This is not a loophole. This is established statutory law designed precisely to protect businesses. The rich just arm themselves with a full understanding of it, while the middle class is told that incorporation is too complicated. A lawsuit starts with an asset search. The first thing a plaintiff's attorney does is hire a private investigator to look for bank accounts, property deeds, car titles, and corporate records. If a name appears on any of those filings, the case becomes economically viable. The Triple LLC Vault uses two states in particular that allow full anonymity. Wyoming does not require the public listing of members or managers. A Wyoming LLC can be filed with just a registered agent and an organizer, and the actual owners remain hidden. New Mexico goes even further. It doesn't require the disclosure of any ownership information at formation or annually. The LLC is a ghost. It pays its taxes, it maintains a registered agent, and it reveals nothing else. The rich stack a New Mexico LLC inside a Wyoming Holding LLC, owned by a Delaware trust. No single state database connects all the dots. A private investigator searching the name Jake will find his BMW, his mortgage, his LinkedIn. Searching Mark turns up a sealed trust and a dormant P.O. box. The attorney calculates the cost of piercing the structure in court. $50,000 to $150,000 in legal fees with no guarantee of ever seeing a single asset. That's the moment the case gets dropped. 97% of lawsuits against properly structured entities never reach trial. They hit a wall of complexity and insufficient reward. Creating a fortress is not about hiding, it's about stacking legal barriers. The process begins by forming the operating LLC in the home state where business is conducted. It obtains an EIN, opens a bank account, and runs the business as normal. Simultaneously, the holding LLC is formed in Wyoming. It applies for its own EIN, opens a separate bank account, and takes title to all valuable assets. The operating LLC signs a formal lease, royalty agreement, or loan agreement with the holding LLC, moving cash systematically upstream. The holding LLC is then assigned to a trust. A competent estate planning attorney drafts the trust with explicit spendthrift provisions, naming the individual's family as beneficiaries and an independent trustee as the manager. The individual resigns as manager of the holding LLC, with the trust appointing a nominee manager if desired. This final step demotes the individual from owner to trust beneficiary and employee. Their personal financial statement now shows minimal assets, a modest salary, and no direct ownership of the high-value holdings. Yet, they control the strategic decisions through their role as trust protector or advisory board member. Annual compliance is strict but minimal. Separate books, separate tax returns, and no commingling of funds. The cost is typically $2,000 to $5,000 a year, less than one monthly payment on Jake's BMW. The protection it buys is infinite. The economy will choke again. Lawsuits will fly. Divorces will shatter net worths. A single slip and fall, a disgruntled employee, a crypto winter, or a liquidity crunch can vaporize decades of work. Jake's failure was not that he earned less, it was that he built his empire on a foundation of personal liability. Mark understood that wealth is not what you show, it's the distance between a threat and the assets. The Triple LLC Vault widens that distance to infinity. It ensures that even if the world burns, the fortress stands. Assets don't get attached. Bank accounts don't get frozen. Life continues without interruption. The banks won't teach this. The typical financial advisor will push mutual funds and life insurance, not charging orders. The system profits when high earners remain exposed, one lawsuit away from reset.